Good morning, everybody. We filmed this, Patrick and I did, because he's not going to be here for today's meeting. But he wanted to go ahead and touch on a very important topic that has come up recently about the difference between the seller in possession addendum and a lease after sale addendum. And so we're going to talk about that. We're going to talk about rights on both of those documents. So with that, Patrick, what's the difference between what we call the SIP, or the seller in possession, and the residential lease after sale agreement? What's the difference there?
Okay. Well, generally, the first difference is the amount of time that the seller is going to remain in possession. Generally, the seller in possession addendum, the SIP, is for situations where the buyer and seller agree that the seller is going to remain in possession for less than 30 days. And that's a one-page SIP addendum, and it creates a license for the seller, who's now the former owner, to remain in possession of the property for up to 29 days. A license is distinct from a landlord-tenant relationship, and it has different rights and obligations as between the licensor and the licensee versus a landlord and a tenant. So the other form, the residential lease after sale, is something that the buyer and seller would enter into if the seller is going to stay in for 30 days or more.
Okay.
And that's the one that creates a landlord-tenant relationship. We can talk about that in a little while. But the less than 30 days, the SIP is it creates limited rights on both sides. Mm-hmm. It gives the seller the limited right to remain in possession for up to 29 days, depending on how long the parties agree to it. But it also gives that seller the right to have possession, and to some degree exclusive possession, meaning that the buyer is limited in their ability to come onto the property. Mm-hmm. And that's limited by contract. The contract itself has an entry provision, which tracks the landlord-tenant, the basic landlord-tenant entry provision.
24-hour notice, that kind of thing?
24-hour notice. The buyer, in the case of an emergency, the buyer can come on without notice.
Sure.
Emergency is not defined, but it's a pretty strict thing.
Smoke coming out of the attic, right? Yeah.
Exactly.
Okay.
Yeah.
Okay.
Okay.
And in that, I saw in the seller in possession, that license you're calling it, and it says that, in fact, in the title. But I saw in that document, it says that the buyer has the right to, come on the property to effect agreed upon repairs. Now, if there are no repairs agreed upon in advance, does the buyer just have the right to show up and start ripping apart the deck or repaving the driveway?
I think the answer to that question is absolutely not. I mean, it's a contractual right that's limited by the terms of the contract, and that is agreed upon and necessary repairs, mm-hmm. and they have to be agreed upon mutually. They can be agreed upon before close of escrow, and if the seller wants to after close of escrow, the seller has the right to agree to have repairs made and for the buyer to come on, but the seller's under no obligation to agree to that.
Got it. Okay, so this is another one of those areas that good communication, good documentation is going to avoid a misunderstanding, especially after close of escrow, because after close, when the buyer and seller are standing in the yard by themselves shouting it out, the next person that gets the phone call is one of us, obviously.
Yeah.
Okay, and there's also been a confusion about keys. We always talk about keys. It closes escrow, and then you have the keys. Either the other agent takes them out of the box, or you bring them over to their office if you're on the seller side, or maybe they come to your office and get them, or whatever transpires there. But when you have a delayed possession, I'm going to call it, where you have a seller in possession here for less than 30 days, there's nothing really that talks about keys specifically. They use the word possession, and if they're delaying possession, does that mean the buyer's entitled to have keys at close of escrow, even if the seller's staying?
I don't think there's a clear-cut answer to that question, at least not in my mind. I think they're like with all lawyers. There's lawyers are two-handed. On one hand, mm-hmm. The seller under this license has some sort of exclusive right to the property, except as as limited by that entry provision.
Mm-hmm.
On the other hand, the entry provision does say that the buyer, in the case of emergency, can come onto the property. So, I mean, it's arguable both ways.
Mm-hmm.
Maybe the buyer's entitled to a set of keys but can't use them.
Mm-hmm.
Maybe the buyer isn't entitled to a set of keys because the buyer doesn't have any particular rights to enter into the property, other than is set forth in the contract.
And again, that would be something that if we're putting together an SIP, we could easily cover that on an addendum.
Yes.
That, you know, the buyer's entitled to have keys at close or not. The buyer's entitled to schedule this type of work or not. Those types of things we should be thinking through, it sounds like.
Those are good things to be thinking about in advance while you are doing the contract between the buyer and the seller.
Great. Yeah, everybody's agreeable before the final ink is dry, right?
Exactly.
Yeah, okay. It's kind of hard to get that agreed to after the fact. So in this lease after sale, you know, we tend to be careful of those because if it's a financed purchase, you know, sometimes the lender will say, our guidelines say that the buyer has to be in the house within 30 days or no longer than 30 days or sometimes 60 days. So sometimes these things can actually interfere with financing. But in the case that it didn't, if a seller gets to stay 6 months, right, and the seller then at the end of that time period moves out, you know, there was no deposit collected, there was just a lump sum for them to be able to stay, or maybe there wasn't even a sum. Maybe the buyer let, as part of their offer, they said the seller can stay in for a few months. And that seller leaves just a ton of garbage and things broken and missing and whatever, and they're gone now. What's the remedy there? I mean, what can the buyer do?
Unfortunately, the remedy there for the buyer is to find the seller and sue him.
Okay.
If there's no security deposit, the damage to the property becomes a tort. It's either, you know, some wrong done to the property, or it might even be a breach of the underlying sale contract in terms of the condition that the property is supposed to be left in.
Mm-hmm.
And the new owner buyer's remedy is to take the former seller to court. If it's small enough amount, it'd be small claims court or limited jurisdiction in the civil courts. That's the way that works. But that's why it's always advisable to get some sort of security deposit.
Right. And, you know, it happened this last year. We got a phone call from another brokerage that one of our sellers had left that way. And the agent said, you know, at the top of their lungs, you need to do something. This is your problem, you know, speaking to one of our agents. So that wouldn't technically be correct, would it?
It is not the agent's issue.
Right, because we're not a party to the contract, so we don't have a dog in that fight.
That's exactly right.
Okay, well, you know, we can have a class more in depth on how to fill these documents out, maybe some of the things to talk about in them as we go forward with our training calendar this year. But Patrick, this has been very helpful because we've seen actually an increase in these types of situations where a seller can't quite get out by close of escrow, or maybe needs to stay until they find something or whatever. So it's important to do these right for sure.
All right.
Great.
Thanks, John.
Thank you, sir.
All right.